him.
Not the portions will not mark not F. F key F to ball. Not the portions will not marked in green.
F
Marked in green.
green.
A to K milot is also having a nipenjana. E is also nipenjana. E থেকে করবেন F থেকে করবে. May I not get a clarification because E is also nipenjana. E is milot on the road. F is milot a portion which is inside milot the plot. Now your lordship has put a pertinent question: from which portion we want to evict him? Can we not consult the BLR because this is not clear from the report from which portion they intend to evict. But my case is that the road is not 604. The road is after 604. Between 601 and 604, there is a road. So we are not concerned with the quantum of land belonging to the writ petitioner. Otherwise, we are only concerned with the land belonging to the PWD, which has been demarcated. He objected to it during the appeal. The appellate authority fixed a inspection. In the inspection, he did not go and say no inspection is required. But the appellate authority insisted no, since you have taken the point, a fresh inspection be conducted. Fresh inspection conducted and the report was not verified that actually PWD land has. So twice inspection has been conducted. But only on this point.
May I submit one thing? They have not stated whether the question whether this is 10 decimals or 9 decimals. They are the owner of 9 decimals. They acquired 9 decimals. Let them submit, let them disclose whether the sketch map on the 9 decimals or 10 decimals.
No, we are not concerned with his quantum of
10
land.
decimals, I have no case.
Only
if
we have
9 decimals, they cannot remove my construction.
If it is PWD land, my lord, then we have a right to evict him. He might have a case with the private respondent, private case, suit decreed, his quantum he may preserve. But that is not by encroaching upon the PWD land. So only I'll get a clarification on this.
I have not encroached any portion of PWD land.
That is absolutely incorrect.
If it is 9 decimals, I have no encroachment.
And two authorities have applied their mind, my lord, factual finding that he has encroached. By mere statement before your lordship, that will not do. There are two orders I have annexed.
That has not been stated whether it is 9 decimals.
They have not challenged the order of the appellate authority also.
Or 10 decimals.
Appellate authority challenge करनी तो रहा. Appellate authority has passed an order that has not been challenged in the writ petition. They have challenged P1 and P6. P1 is the original authority.
10-4.
P1 or P6.
Order of the 10-4 I have challenged.
P6.
DM passed order. Easy. Page 33. Yeah.
কপিতে কোনো ইয়ে নেই, অ্যানেক্সার বোঝা যাচ্ছে না। জেরক্স সাউন্ড করেছে না দেখুন, জেরক্স করে উপরটা কাটা বুঝতেই পারছি না কোনটা পিস।
দোষ কিছুই বলে স্কেচ মারতে। Mr. Banerjee, from your report, it does not transfer where from you want to evict him. It is vague. You have taken no instruction.
He has come up with this report. He was ill yesterday. He couldn't get in contact. So we shall get a more specific report. But so far as quantum, my submission only records that whether it's 9 decimal or 10 decimal, that is within his 604. We are evicting from the government land.
Judgment and decree.
No,
that is not with the government.
Party, you have to relay from your acquired land and the encroached portion.
Yes.
That I intend to see.
No, they are relying on the judgment, which is interstate.
Yes, I have understood.
State is not a party there.
No.
I am not claiming
binding on us.
9 decimals. 9 decimals they can vacate.
He cannot claim anything.
But 10 decimals we are.
He has encroached. Only issue is how much he has encroached.
That is not clear.
That is not.
Yes.
From which portion you want to evict?
Because the acquired land has been marked as not pink. If a lordship sees
that I have understood.
Right hand top.
And these are all encroachments.
These are all encroachments. A to M are all, and the names of the encroachers have been given. In which, my lord?
If it is 10 decimals.
E is Nipenjana. F is also Nipenjana.
If it is treated as 10 decimals, not 9 decimals. If it is 9 decimals, that portion will not be affected. They are the owner of 9 decimals.
Depend জানা, এটা গোপীনাথ মন্ডল।
And in title suit, my lord, the PWD was one of the party. One of the
Lord, may I come back with a more specific report? Kindly take up in the next week, my lord. More specific report now. অ্যাপিলে ও রিফিউজ করে এনকোয়ারিতে পার্টিসিপেট করতে। অ্যাপিলে যখন এনকোয়ারি ফিক্স করলো, Lordship will see the order sheet of the appellate authority. When the inquiry was fixed on his request, he declined to go.
That I've understood.
But there has to be clarity. I understand, Lord. There has to be clarity on which portion we want to. কি বলেছে?
No, wherefrom will get that they want to evict you from 10 decimal of land?
সেটাই। ট্রেনটা
But-
কোথায় পাচ্ছে?
my lord, if it is
I have understood your contention. Your portion is 0.5 and your other side portion is 1/6. Total is 74 decimal.
74 decimals,
And what about the remaining portion?
9 decimals, 9
That
decimals,
belongs to whom?
my lord,
That belongs to whom?
that belong to PWD, acquired land, 9
Huh.
decimals,
Huh?
and Rayati land 74 decimals. And this is specifically mentioned, kindly see the decree, page 52,
Huh?
page 52,
Huh?
second paragraph. It specifically mentioned.
Degree page
plaintiff
number?
right in interest,
Page number?
52, 74 decimals.
Huh? Wherefrom will get that?
Paragraph 2, my lord. Plaintiff's right in interest and also possession are 21.7 decimal and half decimals, and right in interest and 52 point half decimals. Total 74 decimals.
Plaintiff's right at an interest and also possession over 21.5 decimal of land
Of the suit property
of the suit property is hereby declared.
and
And right at an interest of the principal defendant in a group is hereby declared in respect of 52.5 decimal.
total 74,
Yes.
and the rest total land 83 decimals in that plot number.
52.5.
Yes, my lord.
52.5 and 21.5.
74.
Seventy-four decimal.
Schedule.
Yes.
And total land 83 decimals,
Huh?
rest 9 decimals. This is PWD land.
No, wherefrom I will get that they want to evict you from 10 decimal of land.
So that they have not mentioned the
cannot-
quantum of land in their sketch map.
Huh?
In the sketch map, they have not stated the quantum
No,
of
no,
land.
you justify that. Wherefrom you will get that they want to evict you from 10 decimal of land.
I engaged one my surveyor, and after survey, he stated that this is within the 10, this is not 9 decimals. If your land will acquire, then it will
Take
10
down.
decimals. That may be added, my lord.
Why? Have you taken the permission for prior encroachment?
But admitted.
Have you taken the permission of the authority? In writing, there is a provision under the Act for taking permission.
But they are the owner of 9 decimals. They can evict me from the 9 decimals if it is encroached.
Why this will happen? Why you have encroached?
I have not encroached any part of the land. 9 decimals.
Then you remain as it is. You are not going to suffer.
But they are taking the 10 decimals out of instead of 9.
Let them do.
Grateful, my lord.
My lord, item number 4, may I make one innocuous prayer, my lord? My lord, pursuant to your lordship's kind direction, my lord, they have filed a reply, my lord. The state has report affidavit in the form of affidavit. My lord, that has been belatedly filed, my lord. My lord, may I pray for 1 week time to take out an exception, my lord?
না মিলট এটা দিচ্ছ ও
And we have been served on the 10th, my lord.
না মিলট so far this issue is concerned মিলট his lordship has asked
You are appearing on behalf of
respondent number 11 মিলট
Added respondent.
added respondent
West Bengal State Development, Rural Development Agency.
My lord, they were
Executive.
directed to file a report within July 4th positively, my lord, but somehow it has
For the state, Mr. Dhar.
Mr. Dhar
And which the respondent of 4th then?
My lord, this is the report, my lord. Last occasion, my lord was pleased to direct me to file a report where, my lord, in the form of affidavit, and my lord, that report says that there is no such construction is
yes
happening, encroaching to Riot's property.
paragraph 5 10 and 11 lordship will find from this oh acha acha
my lord,
Is
we
there
have
any order of injunction?
yes
yes, my lord,
Yes,
my lord was
yes.
pleased to grant an order of injunction, my lord, on the basis of the admitted report filed on the earlier occasion.
Give me a second, sir.
Your lordship would kindly take your lordship's last order.
এই এটা আমার রিপোর্টটা দিয়ে দাও তো জজ সাহেবকে সুবিধা হবে
ওরা যে রিপোর্টটা দিয়েছে
Yes, Mr. Dhar.
My lord, kindly take up, my lord, Mr. Mullik's report.
report my lord I have just now filed my lord
Who are you, sir? You are the agency.
Agency.
now my lord kindly takes my lord in my report page 4 my lord
Have you submitted to him, Mr. Banerjee?
yes everything has been served
Page number 4.
My lord,
Yes.
we have
number
been
4,
served,
my
my lord, we are yet to
Give
take
me a
out an
second.
exception,
Give
my
me a
lord.
second.
page number 4 my lord firstly my lord clause 5
Yes.
now you are informed that so and so others have filed a writ petition against the local administration demanding compensation for acquisition of land. It is to be noted that there is no provision for such compensation for construction of Pradhan Mantri Gram Sadak Yojana roads. This is number 1. Second, my lord, paragraph 10. The disputed road stretch may be demarcated by the BLR so that we may construct the road on the land which is available for that. And we have no wish to encroach or work on Rayati land without any legal acquisition or without any consent of the landowners. 11. No widening of work has been done on that particular disputed portion and the concerned agency was also instructed regarding the same. Now, my lord kindly takes the page, my lord, page, my lord, 7. In terms of his lordship's order, my lord, we have, my lord, the Cephali construction who is working on this project, my lord. We have specifically told them, my lord, not to carry any work on widening of road so and so, so and so. According to the interim order of Honorable High Court at 11/6/25, the undersigned would like to instruct you not to carry any work of widening of the existing above mentioned road till the last day of August 25 or till further order of the Honorable Court, whichever is earlier. So, my lord, in terms of his lordship's order, my lord, we have complied his lordship's order. And so far his prayer of compensation is concerned, as per my lord, the scheme, my lord, there is no question of any
So
compensation.
you are not occupying anybody's land.
No, my lord. That has been that I have my lord, I have recorded that. And we have so far the work is concerned, that is not within their land, my lord. That has also been mentioned in paragraph 10, my lord.
Yes, Mr. Dhar.
Whatever the, I adopt whatever submission made by Mr. Mullik, whatever the construction is happening only on the existing metal road.
Yes. Not outside.
Very good. Let him come with an exception. They have to accept.
Lordship, my lord.
You have filed any submitted any an separate report.
Yes, my lord. Two separate reports.
One by the state, one
And by the
WPSR.
Very good. On behalf of the respondent number 5 and respondent number 11,
হ্যাঁ, সেটাই।
two separate reports have been filed
কে দেবে?
before this court.
Sanjay Kumar Jana has died. And this is the coming from the Panchayat authority. They are saying with death certificate. মরা মানুষের নামে অর্ডার হয়ে যাচ্ছে।
কত নম্বর পিটিশন? কোন
32 তোমারটা 4 নম্বর আইটেম।
হুম? না, না, না।
My lord, we need to take out an application, my lord. I was absolutely unaware. 32 petition is not possible for us to.
বাকিটা সবই কাটা যাবে আর কি। না ওটা পড়ুন।
With your lordship's leave, may I?
approximately 35 petitioners.
Is the advocate on record? You will be in trouble, I am telling you.
His signature is there, my lord. That's the problem.
My lord, one thing.
He has accepted the Vokalatnama.
Yes, my lord.
And it has not been stated in the Vokalatnama from he has taken.
Your Lordship, my lord, it is due to his inexperience, my lord. He has not done so, my lord. Actually, what we write in the Vakalatnama, my lord, we have learned, my lord, from whom I am accepting the.
Yes.
My lord will kindly pardon him, my lord. Or kindly pardon him, my lord. He is a junior member of the bar, my lord.
That I shall see. How long he is practicing?
2021 enrollment.
With whom he is attached?
Mr. Dinobandhu Choudhury.
Ask him where from you have got the Vokalatnama. Be honest to your court. Be honest to your court where from you got the Vokalatnama.
From client, Your Honor.
All the clients were present before you.
No, Your Honor.
Then
যে দিয়েছে তার নামটা লিখবে তো ধরো রাম দিয়েছে রাম আমার ওকালতনামাটা দিয়েছে but he's E6 my lord what
It's very serious.
prison is not an easy job, I am telling you. Actually, Mr. Banerjee, in the trial court, the style of Vokalatnama is more scientific. That's
Yes,
the high
yes,
court.
my lord. Yes, my lord. So many columns are there. You
The
have
vendors of the civil court in the ground
they
court
have
or
to
the
build up so many columns.
so many columns on the back sides. If it is LTI,
Yes, my lord.
it is to be whom that we have learned in our during our profession.
It is not like our high court's Vokalatnama.
No,
It's different.
it's
In
different,
both the
but
pages,
even
my lord,
then,
you have to fill
it
up
has to
everything.
be Vokalatnama has been executed in such a fashion
Lordship.
that all the 35 executions are present before him and he has satisfied and accepted the Vokalatnama.
My lord.
It's very dangerous, I am telling you.
he seeks unconditional apology my lord kindly my lord his career is at stake my lord
Please explain the situation. Thereafter, I shall consider.
Actually, my lord, he died in 23. That's the whole difficulty. And my lord, application has been filed in 24. That's after 2 years. That's the whole difficulty, my lord. Anyway, let's see.
It is same, but they have not filed the report.
Now, my lord, report is ready, my lord. Otherwise, both the report is ready, my lord. Only things is that my junior has not make it photocopies. So, my lord, I will let Lordship kept with the record, my lord. In course of my lord, half an hour, my lord, he will affirm both these affidavits. Same affidavits. my lord. Same. No, affirm it has been affirmed. Only thing it has not been photocopied to serve the other side. So, in course of today, my lord, it would be affirmed and served to the other side. And both these are ready, my lord. Otherwise, both these are same, my lord, as filed in item number 4, my lord. The same issue. The same issue.
And the same person has executed Vokalatnama.
No, but I believe now there is no. This issue is my lord, not with regard to that.
দেখি ফাইল করে
তো করে রাখবে।
File করে
There is no problem, my lord.
on behalf of the
Yes, 11 and my lord,
for number
state.
5.
Yes, yes, it will be served.
Yes, with sharp.
July 30.
এটা আজকে জয়া চাকরি দিয়ে যাবে কিন্তু।
Very good. July 30.
আমাদের রিটার্নের ফাইলটা স্টেট একই ডেট হলো দুটি এক ডেট হয়নি।
My lord, in this matter, behalf of the petitioner, Mr. Falguni Bandyopadhyay is appearing, my lord. He could not come to the court at least for 15 days. His son died, my lord. Day before yesterday, my lord. And in the item number 7,
এই
we are appearing for
বোর্ডটা ঠিক করুন ভাই, বুঝতে পারছি না কোনটা।
7, we are for
But
the
item number 6, they are the petitioner. Item number 7,
we are the respondent.
they are the respondent. We are the petitioner.
These are connected matters.
Yes, ma'am.
এটা কি 7 না 6? 6 টা দিন তাহলে। 6 who is appearing?
My lord?
6 who is appearing?
6 for petitioner, we are appearing, my
And
lord.
in 7,
In 7, we are for the respondent.
We are for the petitioners in 7.
son of the learned advocate.
That's right.
died. Acha, should I make an order for tagging?
Kindly.
Acha. Next.
I appear for the petitioner, my lord. Last occasion, my lord, directed Mr. Saha and his party.
To impede them and to come up with an affidavit. I do not know whether he has come back with an affidavit or not.
Directed to place a report.
Let the file be placed first.
The report file is it. We have filed our report, my lord. Exception also has been given, but your lordship directed the West Bengal Mineral and Mineral Corporation, Development Corporation to file a report.
No,
Is
Lordship,
that the necessary?
it is only for the purpose of preparation of DSR.
Where is the report?
No, Lordship, I have obtained because we have recommended for preparation of the district survey report. It is yet to, we have received, yet to receive any instruction from the authority whether it has been included in the district survey report or not. Lordship, kindly grant me a week's time. In the meantime, I will obtain
behalf of
whether
the-
the
on behalf
particular
of the-
sand block has been included in the DSR or not.
Ashun. on
Because
behalf of
only
the
for
added
that
respondent
purpose
number
we have been
7.
added respondent.
That is the crux of the matter.
Hmm.
That is the crux of the matter, my lord.
On behalf
Before
ঠিক আছে, এখন তো
English
হচ্ছে
come
না।
on the urgent, come on the urgent, I said.
Sand block এর না যেটা
My lord, respondent number 8, petitioner number 8, my lord, died, my lord.
It is submitted on behalf of the read. এই কবে ডেট দিলাম? 6th August. Who is appearing?
my affidavit of in this matter, what happened, my lord? The grandmother of the petitioners was the original owner of a particular land. Thereafter, the father of the petitioner has got the said land by way of inheritance. Thereafter, the present petitioners got the said land by way of inheritance. The
By way
said
of?
inheritance. The said land is recorded as Vita. And subsequently, the respondent authority wanted to purchase the said land under the direct purchase policy. Accordingly, served a notice to the petitioner. The petitioner appeared before the respondent authority and agreed to sell. But at the time of determination of value, treated the said land as agricultural land instead of Vita land. The petitioner raised complaint to the authority concerned, but the authority concerned did not take any steps on the basis of the petitioner's complaint. On the other hand, without purchasing the said land, is trying to utilize the said land.
Purchase deed has been
No.
executed.
No. Without purchasing. Kindly come to page.
Purchase deed has not been executed.
No.
Then what is your prayer?
They have to treat the land as Vita land and without till such treat the land
No,
of
if
the
you are
master land and determine the
so
value according.
consideration money has been diminished. The proposed consideration money
Yes,
for
yes.
the sale deed has been diminished.
Sale deed, no sale deed has yet been executed.
I
Or-
understand. Proposed that I
Propose.
proposed sale deed has been diminished.
Yes.
If it be Vita, you will get much
Higher
consideration.
market.
higher value. So don't sell.
And don't direct them not to utilize my land. They are trying to utilize my land.
So what is your prayer then?
My lord, he filed an application before the authority, my lord, that is the BLRO, through whether this land is Vita or agricultural land. If that is final, my lord, he will get that
Yes.
sale deed was done, my lord.
They are interim order.
Order will
I'm
be
taking for using the land of the
The land.
petitioners
only
for further
utilize
interested
the land.
along.
Utilize the land.
Yes, only for that reason, my lord, we purchased the land.
Oh.
He agreed to that. But my lord, when it was purchased, that is as a agricultural land, name, that is the valuation was treated as agricultural land. But my landlord said that that is a Vita land. So my lord, he filed an application before the BLR. So BLR will consider and my lord send the report to the appropriate authority. That is,
That is at page number 31.
yes, ma'am.
Yes.
Page number 31.
And I have made also represent to all the authorities. That is at page 28.
Yes, yes.
So let BLRO consider.
Yeah, and send the matter to the
Appropriate.
Respond number 3.
yes, my lord.
Who is the appropriate authority?
The first my lord, he will consider that.
And respondent number 3. Yes.
Respondent 3 will consider.
Nah.
5.
5 will consider and
Respondent
send.
I
the
will
report.
consider and send the report to whom?
To special land acquisition officer, my lord.
Respondent
That is
number
the
3.
Respondent number 3. Respondent number
The affidavit of service has filed today on utilized or not?
Not
No,
yet.
no, no. Huh? কত number 11?
The 11 will I am for the petition.
What is can 2?
Well, can 2 for one injunction, one application for interim order. Last occasion, my lord, Mr. Dhor, my lord, took time, my lord, to take instruction regarding, my lord, the
Where is Mr. Dhar? You are for?
My lord, he is engaged before some other courts, my lord.
You are for?
My lord, I am for the state, my lord. Mr. Supratim Dhar is leading us, my lord. But he is engaged before some other court, my lord.
Very good. 12:30, 12:45?
My lord, can it be, my lord, for one day accommodation?
Not today then.
Number 12.
Last question, my lord. There's direction, file exception to the report. But it is my fault I could not prepare the same. I need some more time.
My lord, this is not maintainable before this honorable court. It is purely land dispute. Vesting has been done. Vesting, I have submitted the report. Vesting has been completed.
So the report of the state government is gospel truth. We have the Panchkula municipality. Hello, earlier occasion,
On behalf of the writ petitioners and accommodation
To go if he is
very good. Come back on 29th. I shall pick up the matter. এটা কি? ও আচ্ছা আচ্ছা, এটা
নিয়ে যেতে হবে, তাহলে এখন আর কি করে, অ্যাডমিন বলে কোনো প্রফেশনই নেই।
This is my application.
হোক তারপর
My lord, in a competitive
give
bidding
me a second,
process,
sir. Give me a second.
guarantee bill number এত amounting এত this will have a release from this end.
What is your affidavit service?
my lord, everybody is appearing.
So in the previous occasion,
Everybody is
you
appearing.
appeared and Lordship directed the state respondents. to-
Yes, what is your report? Mr. Bandyopadhyay?
I'm here, I'm filing.
My lord, may I place my case?
Yes. Extension of mining lease.
Yes.
Yes. Make it up.
What happened? In 2017, there is a auction for competitive bidding process of mining of sand.
2017.
17. I being the
Release from my
L1.
Under the new rules, 2016 rules.
16 concession. I being the L1, I was issued the letter of intent. And the lease deed was executed. Your lordship kindly mark this date.
LOI was issued on
My lord, LOI was issued 3rd January 2018.
3/1/2018. 2018.
And lease deed was executed on 8 March 2018.
Deed
This is
of
the cut-off date.
Deed of lease is
8 May 2018.
8/5/2018.
This is the day of commencement.
On that day, it will appear. It will commence
Yes. From the day of execution, it will commence.
For
Wait.
5 years.
For 5
for
years.
5 years.
For 5.
Then what happened?
Thereafter, certain things were happened. My lord, all on a sudden, on 23rd February 2018, I was asked to construct a temporary bridge. That was
You have been
constructed.
asked to
Construct a temporary bridge over the river.
কে করেছে তোমার বলেছে?
The lease is for excavation.
নিচে থেকে বলো, আমরা
Excavation
কেউ
of
বলি না।
sand.
Why they will ask you to?
For transportation of the tracks, sand.
Acha.
All on a sudden, on 6th June 2019,
6 June.
yes, 2019, SDO suddenly asked me to stop flying the vehicles for transportation.
ব্রিজটা দাও। ভুল বলছো। এটা বলছে বলি।
This was
LOI.
stopped and subsequently resumption was made on
Hello.
30th December 19, after 6 months.
Date, resumption date.
30th December 2019. After 6 months. Again, 4th June 2020, I was asked to remove the temporary bridge and suspension of sand mining at the sand block due to monsoon.
ये बोलो तो कोते
23rd,
As
11th
they asked to remove the bridge.
and stop. Only that is suspension. Due to monsoon, it was suspended for time being. And again resumed. Resumption was done on 23rd November 2020.
Resumption on
23rd November, 23rd 11, 2020. All on a sudden, on 20th September 2021, 10th December 2020, 10th December 2020, I was issued a notice of suspension.
on the allegation.
Allegation excavation beyond the area. That was replied to by me. Since 10th December 2020, there is no communication as to what was the penal cost that has to be ascertained by them, and it has to be served upon me so that I can pay out all the penalties and compound according to law. Nor I have been terminated. By this time, my lord, on 7th May 2023, my lease
So
expired.
after 10th February 2020,
10th
you have
December. 10th December.
10th December.
Yes.
Suspension.
10-12.
10-12.
Suspension was
imposed to
imposed
me. Show cause notice was
along with the show cause.
show cause, only show cause. That's deemed suspension.
You have not been permitted to work.
No.
Then what happened?
By this time, my lord, on 7th.
You replied to the show cause.
Yes. 7th May 2020.
So what will be the fate of what was the fate of your show cause?
Show cause and reply that has not been done by anything. Anything has not been done.
Then what happened?
Well, by this time the lease has expired. I could not work initially 6 months, 1 year. Again, after 20 to 23rd, 3 years, more than 4 years, I has not been allowed to work. Now, what is the law? If there be any violation or irregularities, according to their lease deed, your lordship kindly peruse. Page 85.
No, first show your LOI.
Lordship.
একটু দিন তো ভাই ওইগুলো দিন
49 পেজ
বাবু এটা দাও পেজ নাম্বার
49 মিনিট
Letter is printed 22.
Where is the lease deed?
Lease deed.
Where is the lease deed?
My lord, page 58. Oh, sorry. 58 লেখা আছে না? 85 হবে?
58.
58, my lord, 58.
Yes, 50 পাতা ছিঁড়ে গেছে
8th May. Then
কি করে জানো রসায়ের কবিতে কি আছে
Your lordship will see the my lord, show cause notice, order of suspension, page 111. What is the reason for showing cause me?
দেখুন কথা হয়ে গেছে।
What is the show cause?
111, page 111.
ওইটা দেখতে গেছি গভর্নমেন্টের সার্কুলারটা যেটা আমাদের মনসুনে বন্ধ থাকে। একশো 7।
My lord, may I place 111?
Yes.
This is very vital. Whereas on the basis of report received, it appears that illegal sand mining activities are being carried out beyond the provision of lease by NAS Trading Company, lease of sand blocks such and such. And whereas such illegal activities, this illegal activities is very vital, of the lease area in contravention with the existing rules, guidelines, norms and procedures of the sand mining. Now, therefore, it is hereby ordered that sand block of NAS Trading Company being sand block such and such will remain suspended from any sorts of sand mining operation, including transportation of sand until further order. The lessee is asked to show cause within 7 days on receipt of this letter why appropriate action, including termination of mining lease over the sand block as mentioned above, will not be made. Appropriate action, including termination.
You have admitted your guilt.
Yes.
Then what happened?
My lord. Now, your lordship kindly sees page 85.
Page 112 is your admission of guilt.
Yes, absolutely. Because there is a penal provision, it can be compounded.
Yes.
Page 85.
Yes.
Clause 29.
একটু এসিটা
ডাকছেন, দাদা।
আমার করতে হবে বুঝলে তো পড়া যাচ্ছে না তো
হ্যাঁ, আমারও তো লেজিবল নয়, আমি মার্কার দিয়ে মার্ক করে পড়ছি। আমি পড়ছি দাদা, তারপর আপনাকে দিচ্ছি কপি। 29.
Last paragraph of that particular.
Last paragraph.
পড়তেই পড়ে
Madam, may I read it?
আমরা শুনি।
আমি পড়ছি, জোরে জোরে পড়ছি। The lessees shall abide by all existing laws and rules and regulation enforced by the government of India or the state government or the district authority, and all such other laws, rules and regulation as may be enforced from time to time in respect of working of mining and minerals and other matters affecting the safety, health, convenience of the employees of the lessees or of public. On receipt of a notice from state government, district authority, or from any other from an officer authorized by the state government in this behalf regarding any unlawful or irregular work. In connection with the working of mining, the lessees shall forthwith take steps to rectify the same. The lessee shall also be bound to pay compensation to the state government, district authorities for all losses due to any illegal and unlawful work done by the lessees or his heirs or its employees. Therefore, if the amount is determined for loss or illegal activities, I am bound to pay that. This has never been communicated to me. It has not been done by them. Illegal activities, that is the show cause. If there be any,
No effort was made according to you by the respondent authorities for determining the compensation.
yes,
Payable by you.
according to the lease deed, according to the law also. Your Lordship, kindly peruse the law then. 21(5) to the. There is a penal provision. Yes.
এটা সুপার না
16 rules তো এখানে কি 57 কেন লেখাচ্ছি
এই তো আমি থানার কাছে পাঠিয়েছি কেউ বললো করে
দেখা হবে মানে ভোটটা তুই দেখেছি
এটা হচ্ছে এসডিও করলো এই হচ্ছে তোমার আমার রিপোর্ট
yes clause my lord 50 this is penalty concession rules rule 50 sub rule 5 whenever any person removes without any lawful authority any mineral from any land, the state government or the authority authorized in this behalf by the state government may recover from such person the minerals so removed or where such minerals has already been disposed of the price thereof and may also recover from such person the rent, royalty, tax as the case may be for such period during which the land was occupied by such person without any lawful authority. This is the penal provision. Well, they should have issued me notice raising the penalty according to law. Nothing has been communicated to me. Rather, they allowed to expire my lease deed without allowing me to work in the leasehold property.
Directing them to consider your reply and come to a definite finding with regard to good sub 6.
And the reason.
And at the same time, they will consider your representation regarding by passing.
But they have submitted the report. Report has.
বলবো আবার শেষ হোক
না
সমস্তদা কি জিজ্ঞেস করছে যে
Milord, he has my lord refunded my lord the bank guarantee amount. He asked to pay and he has received.
No.
I have submitted my report, my lord. Did my lord? Yes.
absolutely incorrect statement.
It starts from my lord, page 16
May I have a copy of the
of
report?
the report. No, yeah,
একটা দাও একটা copy
দিয়ে
দাও।
দেবো,
ব্যাংক গ্যারান্টি কবে আমি উইথড্র করলাম দেখি দেখো তো কোথায় উইথড্র করেছি
bank guarantee.
acknowledgement of
Next page, my lord.
Page
He has received acknowledgement, page 17,
on
3rd August 2023. Next page 17. He has received, the acknowledged my lord, the order, bank guarantee. Thereafter, page 18, my lord, stamp paper, bank guarantee. Next page, my lord, bank, ICICI Bank, my lord. Release the my lord bank guarantee. 20 page 20, my lord, your lordship can receive. Serial number 30. We shall be released this time from all liabilities under such and such. Bank guarantee valid up to 37 and 38.
37 is the date of validity. It was valid till 2nd October 2024.
And thereafter, my lord,
Prior to that, it was received back by the
38, 39, 40.
Bank guarantee petition.
Bank guarantee is page 21, my lord, released by the district magistrates. Similarly, my lord, 23, my lord, bank guarantee, another guarantee.
What do you want to say?
There is no case, my lord. My lord, deed was registered on 10th May 2018. It was valid for 5 years. That is expired, valid till 9th May 2023. My lord, a raid was conducted on the spot. Joint raid was conducted, my lord, by the team comprising SBO Bishnupur, SDLR of Bishnupur, BLLR of Patrashire, and my lord, based on the report filed by the SDO, my lord, your lordship kindly turn to page 7. Page 7 of the 7 is the report of the report. That is the report.
Page
He has
7.
excavated beyond his, my lord, area.
That they have admitted.
Admitted. And my lord, accordingly, he was suspended.
True.
Police was taken step, my lord. Police report. The police to kothay gelo?
No, why have not done then terminated his lease?
Yes.
Already it is expired, my lord, and he has refunded, my lord, taken the refund of the bank guarantee. And there is no case of, my lord, extension released. Officer in charge, Patrashire, page 4.
No, I understand. In the event, if you are not satisfied with his reply, what action you have taken, that I intend to know.
That I have no instruction, my lord, to
That is the case here. They have to act in terms of the law, not beyond that.
As your lordship, my lord.
Take down.
Let the representation be considered after giving opportunity of hearing. Well, record on your submission, the bank guarantee was already released.
No, not released. My lord, your lordship kindly sees the report.
Released.
Your lordship kindly sees the report. After the expiry of the lease, the district magistrate Bakura released two bank guarantee to Nas Trading Company such and such. That was received. Letter was received by the Nas Trading. Where is the money credited to my account or I have withdrawn?
Bank has already been received. The
Bank guarantee,
bank is released.
With the bank guarantee.
There is no question of liquidation money.
Money. ICICI has been given
Yeah,
the
And that is
That is
after expiry of lease.
beneficiary. Page 19, 20.
The law says he has to, my lord, statutory, he has to comply the statutory provision, imposing
Bank already
penalty.
released.
The parties are represented by their respective
Already disposed of, my
Wrongly appeared, he's saying.
আমাদের ডিসি পার স্কুল কাউন্সিল এই ওই এফিডেভিটটা দিয়ে গেছিল তো দাদা 4-5-এ যাক 5 নম্বরটা দিয়ে গেছিল তো এফিডেভিটটা
And for the state.
হ্যাঁ দুটো
No, I am for the read.
that affidavit has been my lord given
Very good. Thank you. Pleadings are complete, Mr. Ghosh. Mr. Bosu Mollik is for the DPSC,
CPSC lordship
Primary Council.
primary council
And who is for the state? You are for the state. Yes, Mr. Ghosh.
Lord, the writ petition of the year 2012, Lord, my lord will find there is a two substantive pleadings from my part. One is the writ petition, another is the supplementary affidavit. Lord, my lord, be pleased to take up the supplementary affidavit also.
Yes, supplementary affidavit is there.
Most of the case, Lord, I shall place from the supplementary affidavit because, Lord, when the writ petition was drafted, I was not there. Lord, there was some misstatement and something like this. Lord, I cannot justify right now. So whatever the case may be, Lord, I am making it cut short for proper adjudication of the case. Lord, there are so many prayers made in the writ petition. I am today, Lord, I am concentrating on the prayer A only for appointment.
Prayer A of the writ petition.
Yes.
What is that? Let me see once. Read to consider and include the name of the petitioner in the list of selected candidates for recruitment to the post of assistant teacher under the Hooghly Primary School Council.
Yes.
Very good.
Other prayer,
You
Lord,
are pressing prayer A.
prayer A only.
Yes, sir.
Lord, the short fact of the case is that, Lord, the petitioner is a orthopedically handicapped candidate. Lord, he registered his name with the Employment Exchange of Arambagh, Hooghly, in the year 1991. Lord, on 19 January 2007, the respondent number 3 and 4 for the first time informed that my name has been.
Have you given any list of dates?
No,
I believe you are reading from a list of dates. Have you given any?
I am not reading from my list of dates, my short notes.
Oh, I see. Very good.
My short notes.
Very good, sir.
Lord, they kindly come to page 38 for the convenience of Lord, my lord. 38 of the writ petition.
Page number 38 of the writ petition.
Of the writ petition.
Oh, I see.
My lord has to take trouble. There is some documents in the writ petition, some documents in the supplementary affidavit.
It happens with old cases. What can
Yes.
be done?
Page 38.
Yes, sir.
Respondent number 3 and 4 address this letter to my client dated Lord 19 January 2007. By this letter, it was informed that my name has been sponsored by the Employment Exchange for the post of assistant teacher. And I was also requested to fulfill certain criteria which has been mentioned there.
Not criteria, submit following documents.
all following documents. Next, Lord, it 2000, Lord, the 2009, Lord, the 2009
Mr. Ghosh, you have stated that your person is an orthopedically handicapped.
orthopedically handicapped.
Have you got any physical disablement certificate?
Yes, yes. This certificate has been annexed with the
Very good,
registration.
very good. You do your in your own way.
Yes.
I'm not.
And
going
that
to
part
interrupt
is
you.
not in dispute by the respondent
Very good.
also.
So page number 38 is the relevant memo by which some documents have been asked for.
Asked for. But when this was issued, but on 19th day of January 2007, at that relevant point of time,
yes, sir,
all the teachers to the post of assistant teacher of the primary school was being regulated under the West Bengal primary school recruitment rules.
West Bengal primary school
recruitment rules 2002.
Yes.
Then Lord, kindly come to page 39 of the declaration.
Yes.
Lord, written test was scheduled to be held on 20th December 2009.
So I'll get that.
Lord, the page 39 middle portion. Page 39 of the writ petition, Lord.
Yes. Page 39 or 40, sir?
39, Lord. This document, Lord.
That is at page number 40. To Sajal Mondol,
Yes.
later date, memo dated 1/12/2009. He is requested to appear at a written test on 20th December 2009.
Yes.
This document.
This document.
Then page number 40. Yes.
But before this appointed date, trouble started because the West Bengal primary school recruitment rules 2001 suffered an amendment in the year 2009. And such amendment says that all appointments shall be made by the selection committee, not by the employment exchange.
Employment exchange do not.
Name shall not be considered. Even the name whose name has been considered by the employment exchange. Previously, this was the practice. Lord, the name should be sponsored by the employment exchange, and the in due process of the course of the law, and the name the selection was held, and the teachers was appointed. This was the regulation according to the West Bengal primary teachers recruitment rules.
2002.
2002. Then, Lord, it suffered amendment in 2009. 2009 says
yes.
2009 amendment says that appointment should be made by the selection committee. And Lord, those whose name was sponsored by the concerned the employment exchange, they were excluded by such operation of the amendment. That amendment was challenged by filing a writ petition before this Honorable Court. Honorable Court given direction upon the respondent number 3 and 4 and the education department. Then a notification was issued. Kindly see that notification. That is annexed with the supplementary affidavit. Page 27.
Yes.
In continuation to this office number 401 so dated 5th August 2009, read with corrigendum issued white number such and such dated 31st August 2009. This is to state that the pursuant to the order dated 23rd day of March 2009, that was the order passed by this Honorable Court, issued by the Honorable Justice Soumitra Pal in connection with writ petition number 15800 of 2008 of 2009, recruitment of the primary teachers in the vacant post arising from 2004 to 2010, the process of the recruitment was bifurcated. Those candidates who had
The recruitment of primary teachers in the vacant post arising from 2004-5 to 2000, the process of recruitment was bifurcated. Very
bifurcated. Those candidates who had applied through employment exchange, like my client, against the vacant post in 2004 to 5, 5 to 6, 6 to 7, had to be considered pursuant to the recruitment rule prevalent at the material time as per the order of this Honorable Court. The process of the conduct of the examination, preparation of panel and issuance of the appointment letter have now more or less completed in respect of most of the district. The district primary school councils are now to take up the application against the post in 2007 to 8, 8 to 9, 9 to 10 as per the modified recruitment rules issued under this office memo number such and such. All the district primary school council have already issued the press notification intimating the category wise vacancy for information of all candidates, and all the district primary council who also issue the necessary admit card to shortlisted candidate immediately intimating the center and the date of the proposed recruitment examination. Therefore, Lord, according to their own notification,
that means 2004 to 2007 one process, and 2007 to 2010 another
process. So I comes the first category.
To be considered pursuant to the rules prevalent at the material time. Rules means in 2002 rules.
2000 earlier rules.
I mean unamended rules.
Unamended rules.
So, Mr. Ghosh, according to you, as per this circular, your client comes under 2002 rules unamended.
Unamended.
That is your contention.
Yes, that is my contention.
Just a minute, sir. So, as per this circular, the candidature of the writ petitioner would be governed by the unamended rules of 2002. Very good. Next,
Lord, kindly come to straightway the page 31 of the supplementary affidavit. A advertisement published by the respondent number 3 and 4. That is the concerned advertisement in pursuance of which, Lord, the selection was held.
Yes.
Lord, I will show some arithmetical calculation from here. Lord, kindly come to serial number 1, this middle portion, Lord.
Yes. Hooghly Jela.
হুগলি জেলা ফার্স্ট আনুমানিক শূন্য পদ সাধারণ সংখ্যা such and such. Total, Lord, the vacant post was, Lord, 135.
That is in case of শারীরিক ভাবে অক্ষম,
That is,
physically handicapped.
yes. Lord, kindly take notes of the date of the notification. That is 30th August 2009. Then
Yes.
Lord, this total number of vacancy 135, it should be, Lord, divided by 5 years. Because according to page 27, 2004 to 5, 5 to 6, 6 to 7, 7 to 8, 8 to 9. These 5 years, 135 divided by 5 into 3. Because Lord, my category comes from 2004 to 5, 5 to 6, 6 to 7. Lord, I am repeating.
Why?
I
will make a division.
Lord, because other
135 is the accumulated vacancy of 5 years.
5 years. So, Lord, unless there is a equal distribution, that has to be the equal distribution.
Where from will get that?
Otherwise, Lord, there shall be injustice to me, Lord. There shall be injustice to me.
No. Vacancy of a particular year is carry forward to the next year. And that vacancy is also forward to the next year. Ultimately, the total vacancy at the end of that block year is 135. So where from will get the concept of division?
Lord,
135 per each year.
Lord, otherwise, how they will distribute the vacancy amongst the 5 categories?
Listen, suppose I'm talking about a district judiciary. Suppose in the year 2022, 10 numbers of Group D retired. In a hypothetical situation, I am telling you. No vacancy, no recruitment process took place. 2022, 10. Group D. 2023, 2. 12. 2024, in the month of December, say another 10. So 10 plus 2 plus 10. So as of the last day of December 2024, the total vacancy will be 22. And if the district recruitment authority decides to hold a recruitment process, say in the month of October 2024, what will do? He will declare the present vacancy and the anticipated vacancy as on 31st December 2024. So 24 will be the 22 will be the total vacancy. Over that, recruitment examination will go conducted. And in the event at the time of recruitment examination, the age limit is 40. Can it be divided into that fashion? It cannot be.
Because, Lord, here some distinct features is there. Distinct features is that, Lord, the rules suffered an amendment. There, Lord, the rules.
No, where from you will get that rule? Where from you will get this rule that this vacancy will be divided according to the year? Where from you will get that?
Then, Lord, I am putting this question to myself. And my Lord,
you are not the rule making authority. Rule making authority is there.
I am not rule making authority.
You have not challenged the rule.
Lord, then kindly come to page 65 of the writ petition. Then in what manner they have distributed this seat, Lord, the post? I fail to understand.
No. So far as this শারীরিক ভাবে অক্ষম, that means physically handicapped.
Physically handicapped.
Physically handicapped is 135.
135.
So how do you divide this into 5? That I intend to know. I understand your contention. That is page number 27 you have referred, no?
Yes.
2004, 5, 5, 6, 6, 7.
Yes,
You come under this zone.
this zone,
So three years.
3 years.
And if you say that 2004, 2005, 2006, 2007 is with 5 years.
Yes.
4 years.
4 years.
4, 5, 6, 7. Be there as it may. It is for, if I accept this as a financier, is for 3 years. So why it will be divided by 3 or 5?
It will be divided by 5 because blood the 3 years, blood the first segment 3 years and the latter segment is the 2 years. That is why blood that should be the divided according to me. The 135 total vacant posts shall be divided by 5 and it will be multiplied by 3. If it comes, the total vacancy will come blood 81, whereas the blood they have given the 65 numbers of vacancy. Rest where they concealed. If there was no sir concealment, then blood my candidature could have been blood considered by the respondent number 3 and 4.
No, as per this circular, how they have.
No, there is nothing.
Huh?
As per the page 79, page 27, there is no indication for blood distribution.
Huh. The rules are different.
Rules are different.
Now, how you are making an distribution? There I feel to understand, Mr. Ghosh.
Blood unless it is being blood distributed. Blood some candidates' name was sponsored by the blood the employment exchange. After 2009's amendment, blood they are not entitled. How the unless until the blood the seats are given to them, and the separate examination was held for them also. Blood the for first three years, first 3 categories, blood the separate examination was held, and for last 2 years the separate examination was held. This is not that all the candidates sit together.
And process is with regard to which category of candidates?
My lord,
this recruitment advertisement is for which category of candidates?
Lord, for the post of assistant teacher.
No. Those related to which pertains to which years?
Physically, blood the handicap candidates.
No. For which years? Which block years?
Which blood the 2004 to 2009?
2009 or 10? 2009.
2006 recruitment process, examination held in 2009. The recruitment process is of 2006 and the examination was held in 2009 because of certain litigations, and Lordship knows that Tulsi Bokshi and all these matters are there during this pendency of this.
No, Mr. Ghosh, I am not clear on this point. What you are going to submit?
Lord, this is Lord I want to say Lord this is Lord, my submission that the 135 post it should be Lord divided by 5 multiplied by 3. Because this is
why it is divided by 5 and why will be divided by into 3? Where we are getting the rules? Why have not challenged the vacancy position at that time? They have participated in the recruitment process.
That was not challenged.
Then, so you must have a logic, I believe. If that be the logic, what prevented you from challenging the recruit vacancy at the time of the material time?
That was not challenged, Lord.
Then, sir, you don't have any case.
That was not challenged, and I can improve at this stage, Lord.
Then you don't have any case. Take down.
My lord, I was granted, my lord, a mining lease for, my lord, sand, extraction of sand. But it was dated, my lord, 31st of December 2018. Uh, my lord, yes. But pursuant thereto, lordship. Yes. But I was given possession on 24th January 2019. The lease was for 5 years. According to the rules from the date of registration, our case is that it should be deemed from the date of possession. They in their opposition says that according to the rules, it should be reckoned from the when the lease is registered.
So almost after a month, almost after a month.
Yes.
Less than 7 days, 3 weeks.
I will just give a short overview because Lord, eventually Lord, I'll be praying for Lord, relief. But I was subjected to penalty on an allegation that Lord, I have mined Lord, the area outside Lord, my periphery of lease.
Like previous case.
Lord, these are Lord.
Here he has denied in the previous matter.
No, here it was struck down by the High Court. They themselves, Lord, after Lord, yes. I'll just come one by one. There was an allegation, 81 lakhs and odd, Lord, the penalty was imposed. That was Lord.
Excavation beyond the notified, beyond the leased out area.
Leased out area. Thereafter, Lord, they themselves, Lord, said no, there was a miscalculation. You have to pay 47 lakhs and odd as a penalty. I went up before this honorable court. This honorable court set aside that order. That order is at Lord, page 149. Lord, no, Lord, it is not at 149. Sorry. It is at page, it starts at page 138 and the operative portion is 140. But kindly have that paragraph starting from at page 140. I find from perusal of the impugned notice of demand.
Yes, sir.
Lordship. Then, Lord, this honorable court said that accordingly I am of the view that there is no reason whatsoever in the impugned demand notice in view of aforesaid the impugned notice dated such and such of the writ petition is quashed and set aside. I direct the additional district magistrate and DL and LRO Purbo Bardhaman to give an opportunity of hearing to the petitioner, possibly within 7 days from date, and conclude the proceeding pending before them within 3 weeks from the date of communication of this order. So, Lord, that 47 lakhs the penalty that was imposed, set aside by the High Court for want of reason, sent back, Lord, to the DL and LRO.
Conclude the proceeding means which proceeding?
But the proceeding concerning, Lord, recovery of, Lord, the penalty, the determination of the penalty. Then, my lord, an order was
No, sir. The penalty amount as imposed was 47 lakhs and on. Am I
Lordship.
correct?
Lordship.
That was set aside.
Set aside.
That but proceeding directed to be continued.
Yes, so far as not the quantification of that penalty amount is concerned. That I will not point out before your lordship, not the order of the DLLRO. It starts at page 149. And Lord, the concluding portion is not.
So proceeding was not quashed. The amount was
order was quashed. Order quantifying 47 lakh was quashed.
Very good. Then what happens?
Then it's sent back Lord, on remand. It starts at page 149, Lord, the order passed by the DL and LRO. The DL-LRO, Lord, at page 152 said, page 152. Starts at 149, page 152.
Yes.
But I'm just reading, Lord, that operating portion.
Please, please.
Lord, at 150. Now that the said demand notice issued by the ATM and DL and LRO has been quashed by the Honorable Court, it would not be feasible for the undersigned on this day to determine the quantum of stock of sand which was stacked in the leasehold area after a gap of 2 years. Moreover, on the basis of the statement of the RI, the revenue inspector, the penalty amount was reduced, but presently the same cannot be relied upon as there is a gross disparity about the quantum of extraction of sand during that period. The lessee was handed over possession on 24/1/2019, while the joint inspection by the SD and LRO Katwa BL LRO Mongolkot with the officials of ADM and DL and LRO Purbo Bardhaman and DL and LRO Birbhum and SD and LRO Bolpur BLLRO Nanur was done on 22/2019. And the BLLRO Mongolkot issued a letter to Pradeep Arora, that is my client, on 25/4/2019 imposing a fine for illegal extraction of sand for 54 lakh cubic feet beyond the leasehold area. Later on, the revenue inspector deposed that the said illegal extraction would be 11,50,000 cubic feet, but such quantum of illegal extraction of sand within a span of few months is not believable, as no complaint of illegal transportation of sand from the sand block was lodged during that period. Thus, from the deposition of the RI and the evidence on record, it is clear that there had been some foul play. After perusing the document, it is also crystal clear that the witness who signed the measurement sheets were not employees of Pradeep Arora. So, considering all the above facts and circumstances, it is hereby ordered that the prayer of the applicant is allowed, let the sand block such and such located in the plot number such and such be reopened and the applicant Pradeep Arora be allowed to carry on his business. The concerned BL and LRO is directed to issue challans to Pradeep Arora according to as per law.
So on remand, Mr. Mukherjee, the ADM LRO could not quantify the penalty. So he has decided to allow the mining.
Allow mining. So there was a gap of 29 months, Lord, due to Lord, the action of Lord, the government, which ultimately Lord, resulted in this.
You could not excavate.
I could not, because there was a stoppage order, and Lord, they now by this order permit my client Lord be allowed to carry on his business
with effect from that day.
Yes. So that day is Lord September 2021, 22nd September 2021.
And when you have been suspended?
Lord, it was in April 2019. And I was Lord given possession on 24th January 2019.
When you were suspended?
But suspension, first Lord, the show cause 88 lakhs came in April 2019.
So from April
2019 to September 2021.
To September
2021.
You could not excavate.
I could not excavate.
You want extension of that period.
Yes, no, there is a bit more to it. Because I'll be adding blood something to it. Because that will show that blood there was a blood assurance given by the government side, blood that there might be an extension. And but I'll thereafter place the rules because they will be relying upon the rules to say that the 5 years period is very rigid. It is their defense. I cannot do that because of the rules say that I have to again auction the property. Because after expiry of the lease period, the sand block will vest into the state. I have no option but to give it on further auction for lease. This is their the stand in general, subject to what my learned friend clarifies. Now, after the order of the DLLRO was passed, I gave a repeated the representation. These representations are at different pages that I will point out before your lordship. Now, your lordship will kindly come to page 165 for once.
Hmm. 165, sir.
165.
Yes.
165. Now, Lord, this is based upon my application and this was given in 2023. Because, Lord, all through I say that you kindly extend my period Lord, this is addressed to by the additional district magistrate and district land and land reforms officer
The departmental secretary.
to the secretary with a copy to me, Pradeep Arora, copy number 2. With reference to the above, the application of Sri Pradeep Arora dated such and such, along with all attached document is being forwarded to your kind end as decided in the DCCB DLSC meeting dated such and such. Resolution attached for perusal and necessary instruction to this end for next course of action. So, Milord, it was sent to Milord, the Secretary, the Government of West Bengal, Industry and Commerce Enterprise.
For taking decision.
For taking decision, I'll show Milord, they have annexed Milord, the decision of this committee. District level sand mining committee. That
No, enclosure is your application.
Enclosure is my application, but those are Milord, on the pre-page, your lordship can see 164, my letters. My letters. Those are Milord.
Those have been annexed with these letters.
Yes, those have been annexed. Yes. Then your lordship will kindly have a look at Lord, the pages Lord that I have Lord marked are those Lord. The prayers Lord, repeated prayers at page 176 for extension. Now, in the meantime, Lord, I will just point out another letter which I have Lord omitted to show in the chronology. Page 148.
176 is your representation.
Representation. My prayers will be for consideration of these representations.
One 146.
148, Miller. This is dated 1st of June 2021. With reference to the above mentioned, actually, with reference to the above mentioned matter, this is to inform you that the LTML may be extended for the period during which it had remained non-operative after 31/12/2023 if law permits. This is for your information. So, my lord, this is a very important letter. Issued to my client in reply to his request.
the kind of assurance.
Kind of assurance.
If law permits.
If law permits. Now I have to show whether not the law permits and whether they have taken a decision on it.
Whether they have
taken a decision in terms of Milord, the meeting, in the meeting they have held that it should be decided by Milord, the superior authority, that is Milord, the Industry and Commerce Department. So whether that has been done or not. So Milord, they assure that if law permits, we will consider. Then Milord, kindly come to Milord, the decision of the Milord, the district level sand mining committee.
Page number?
Page number, Milord, kindly take up their Milord opposition. Page 47. Opposition, page 47. This starts from 46, but the decision is at page 47.
Affidavit in opposition.
In the affidavit of opposition. The back sheet of Mr. De.
I've got it.
Yes.
Proceedings of the meeting. Of
47, yes. 47, Lord. The
Give me
second
a second.
paragraph. I'm sorry.
Very good. Page number 47.
47. Lord, above Lacey has submitted the second paragraph. This is Lord concerning my client. Prayer to the district magistrate for renewal of LTML, long-term mining lease, citing the compensation against inoperative period of 29 months owing to hearing proceedings on a complaint against illegal mining, which was later absolved by DL and LRO in an order dated 22/9/2021. This is decided to be forwarded to the Department of IC&E for necessary instruction.
So they have sent the ball to the court of the department.
That is at Milord, which I pointed out, Milord, the letter given at page 165 of the writ petition.
Yes.
165, they forwarded to the Secretary, Industry, Commerce and Enterprise. Page 1. Then, Milord, kindly see. Milord, the rules that they rely upon in their affidavit in opposition, Milord, starts from page 17, opposition 17.
One seven.
But at page 1A, Your Lordship got Lord, page 17. Kindly turn over to page 18 because the
Yes.
the next page, page 18, period of lease, item number 5, rule 5.
Yes.
For riverbed occurrence, moram and earth up to 10 years, for other minerals up to 20 years. Period of lease for mining operation in any area shall be for riverbed occurrence, moram and earth up to 10 years. B, for other minerals up to 20 years.
So we are now with A.
My argument will be that even if they have granted the lease for 5 years, there is no embargo in the statute, my lord, that they cannot extend it beyond 5 years. Suppose my argument, I would not have made this argument if the law said that the lease can be only for 5 years. Then, my lord, 5.2 is date of commencement of the period for which a mining lease is granted shall be the date on which a duly executed lease deed is registered as per the condition laid down by these rules. So, my lord, the date of registration of the mining lease is the date of starting point of, my lord, the lease, periodic lease. So, in this case, my lord, it is their contention that, my lord, it has ended on, my lord, 31st December 2023. Because 31st December 2018 was the date of execution.
So 30th December 2023.
Lords.
5 years. Next.
Now, my lord, your lordship will kindly have a look at, my lord, the sand mining policy that they have, my lord, annexed at page 39. Then, my lord, your lordship will kindly turn to, my lord, page 41, III.
Policy
Transfer of existing mining leases.
2021.
Lordship.
Page number 40.
No, my lord, it starts at, my lord, 39.
And that
Kindly have a look at 41.
Page number 41.
41.
Yes, sir.
Lord, III about, Lord, fifth line from top, transfer of existing mining leases. In existing leases, the lease shall not renewed and shall automatically be resumed and vested with the state government upon expiry of such leases. The state government shall then lease the sand mines to WBAMDTCL or any agency recommended by it. This is, my lord, pursuant to, my lord, a policy of the state government. It is not a statutory rule. This is not, that's the reason I pointed out page 39 to say this is not a mere policy. Then, Lord,
so policy according to you must succeed to the touchstone of the
policy is, Lord, much is inferior quality than, Lord, what
that
the rules say.
that must succeed to the touchstone of the violence of the act.
Yes. They cannot, Lord, there cannot be a policy contrary to, Lord, the statutory rules or, Lord, the statute. Then, Lord, at page 42, your lordship will kindly say they rely upon, Lord, the rules, West Bengal sand mining, transportation, storage and sale rules 2021. This is a rule.
Subordinate registration.
Yes, because, Lord, the parent legislation is Mines and Minerals Development Regulation Act, Lord, 1957, MMDR Act.
57 Act, yes.
That is, Lord, the regulating act. So, Lord, this is, Lord, what the rules say. But kindly now turn over to, Lord, page 44. 5. The period of sand mining lease shall be minimum 5 years and maximum 20 years. Then, I'm sorry. So, my lord, here, my lord, this rule say that 5 years minimum, 20 years maximum. So, my lord, I say that if you consider 29 months, you are not going beyond even your rules which say the maximum is 10 years. So my case is, my lord, admittedly, I was not allowed to operate for 29 months. I was given an assurance that it can be extended if law permits. Then, my lord, the committee takes a decision that it should be sent to, my lord, the state government's, my lord, one of the higher wings for a decision. The decision not taken.
Not taken.
Not taken. The state government comes and, my lord, gives an affidavit in opposition before your lordship to say that the tenor of their opposition is, no, I cannot do that. 5 years is over. I have to put the sand block for auction. Therefore, I have got no power to extend it.
Without taking decision, they have communicated this.
But the decision is not communicated to me, my lord. So, my lord, that is not before your lordship, either in their opposition or in my writ petition, obviously.
Ultimately, they are not extending. That is your main
That is,
purpose.
they have not extended. They have not even taken a decision whether they will extend it or not. Even, my lord, the committee has, my lord, relegated it, my lord, to the higher authority. Page 65. And, my lord, the decision, my lord, that they had taken, I have already, my lord, placed before your lordship at page 47 of the AO. So that is my case.
Very good.
So, my lord, on the point of law, I say that, my lord, that even if they extend, it doesn't, my lord, go beyond the maximum permissible timeline. Let us take the maximum permissible timeline for a lease is 10 years.
Then what is your prayer, sir?
But, my prayers are at page 27. My prayers are, my lord, to consider the representations dated, my lord, such and such. These are all representations for, my lord, extension. And, my lord,
You have not prayed for any issuance of mandamus for extending that period.
yes, my lord, yes, my lord, just a moment, my lord, yes, D, prayer D, yes. Prayer D. To add the period during which, thank you.
I believe that you are now pressing practically.
But that is I am pressing, yes.
You are not pressing prayer B at least.
Lord, that is prayer D is I am pressing.
That I am saying. For the present, you are now pressing prayer D.
Prayer D and prayer E also, Lord.
The E is the consequential to prayer D.
Because, Lord, if your lordship kindly comes to page 51, your lordship will find, Lord, when they allocate, Lord, a sand block, they also say, Lord, how much, Lord, the sand is to be extracted.
On the basis of that, royalty is determined. Yes, Mr. They.
My lord, the main contention is that, my lord, I may not want to go into all the merits or other things. My lord, we have already, my lord, that is in our affidavit in opposition, my lord. If your lordship will come page 4, Roman 12. My affidavit in opposition, my lord.
Give me a second, sir. Page number?
Page number 4, my lord. Roman 12.
Yes, sir.
That is the district level sand committee of Purbo Bardhaman decided in its meeting which was held on Ato that the prayer for extension of sand mining block shall be forwarded to the Industry, Commerce and Enterprise Department, Government of West Bengal for necessary action. My lord, I have already sent the matter to the Industry, Commerce and Enterprise Department. So, my lord, he will take the appropriate action against the
departmental secretary is not the party.
Yes, my lord.
You are representing him.
Department in name.
আপনি তো represent
না 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 আমি তা বলছি না
এফিডেভিটটা হলো আপনার এডিএম ডিএলএল
না না আমি যেটা বলছি যে মাই লর্ড that was forwarded, that was not considered yet. For that, my lord, your lordship was directed to
the principal secretary is there.
Yes, my lord. For that was not considered as yet. So, my
Who
lord,
prevented you to consider, sir?
my lord, that is the problem.
It has been forwarded to you
On-
in the year
on 2nd August
23. You
Yes,
have
my
not
lord.
taken a decision.
August 2023. Not taken any decision.
Then why the court will not allow the prayer of the writ petitioner?
As because, my lord, as your lordship can give some time to consider
No,
that
what
aspect.
justification is there for withholding your decision for not by not taking appropriate
As-
decision?
They are losing revenue in the meantime.
But my lord, as there is no other alternative, my lord, I can't say anything. My lord, that is the only thing, my lord. They sent the matter and they are now, up till now, my lord, no decision was taken.
Very
Only for
good. That is one point. How do you justify your action? You yourself suspended him. You yourself
lord,
could not prove the.
My lord, I have, my lord, it is a very easy thing, my lord, to the principal secretary to give the my lord decision. Then, my lord, nothing will be happen, my lord. The decision was not done, my lord.
No, sir, Mr. De. Sir, try to
I-
understand my question.
Yes, my lord.
Don't bypass my question. What prevented you to extend the lease? How do you justify your action when you yourself has failed to
My lord,
justify your action by imposing a penalty or compensation under this
my
said
lord,
rules?
in my affidavit in opposition, I have done so, my lord, that this is the position of law and this is the position.
What can be said, sir?
But lastly, my lord, they send the matter to the
রুলসটা কি হলো? রুলসটা কে নিয়ে গেল? প্রধানবাবু, I'm sorry.
আমার এর মধ্যেই তো দেয়া আছে।
Got it.
হ্যাঁ, আপনি দিয়েছেন।
আমার এর মধ্যেও দেয়া আছে, my lord. আমার এফিডেভিট ইন অপোজিশনের মধ্যেও দেয়া আছে রুলস এন্ড আদার থিংস, my lord.
Take down. এগুলো সব খুলে যাচ্ছে ভাই, একটু ঠিক করে রাখুন, নাহলে আজকাল কেলেঙ্কারি হবে। হুম। 60, একটু ওনাকে রাখুন তো 2 মিনিটের জন্য। Yes, sir.
My lord, a proceeding was initiated under the West Bengal Land Requisition and Acquisition 1948 for the purpose of construction of sluice gate.
For the purpose of
Construction of sluice gate.
sluice gate.
Sluice gate.
In the use as is used in the dam.
Use in the dam or in the canal or etc.
No, be that.
Be that. Now, my lord, the facts that has been stated in the writ petition has been admitted by way of filing an
Is it Act 2 of 1948?
Act 2 of 1948.
Your all cases are deal with Act 2 of 1948.
Now, my lord,
Yes.
now, my lord, lordship knows, my lord, the
Limited period act.
Yes. Possession of the land was taken over on, my lord, February 7th, 1990.
Possession was taken on
February 7th, 1990.
Yes.
Upon invoking, my lord, subsection 1 of section 3 of the Act 2 of 1948. Now, my lord, Act 2 of 1948 expired on 31st of March 1997.
Possession 7/2/1990.
31st March 1997, Act 2 expired. Now, during the lifetime of this Act 2, my property was never been acquired. Upon publication of a notification under section 4(1)(a).
Give me a second, sir. Act 2, 1958. Expired on?
Act 2 expired on 31st March 1997. Now, during lifetime of the Act, the collector never made any attempt to acquire my land. Never made any attempt. Meaning
No,
thereby
3131 means the acquisition.
Requisition.
Requisition, I'm sorry.
So, my lord, the property was not vested with the state.
4 not complied with.
4(1)(a) not complied with. So, property was never been vested with the state. I am the still owner of the property.
Absolutely.
If you will kindly turn to section 4(1)(a). Lords got it.
By publishing
The state government may acquire any land requisition under section 3 by publishing a notice in the official gazette that such land is required for a public purpose referred to in subsection 1 of section 3. Subsection 2, where a notice as aforesaid is published in the official gazette, the requisition land shall on and from the beginning of the day on which the notice is so published vest absolutely in the state free from all encumbrances. So, in
4(1)(a) not complied with.
Not complied with. Not published. So, meaning thereby, my lord,
vesting remains are incomplete.
Vesting, but so I'm the owner of the property.
You are the owner.
They are enjoying the possession by way of requisition. And requisition continued, my lord, up to 31st March 1997. I tell you, lordship, why? Because the moment Act expired, then, my lord, to continue with this possession and for the purpose of making declaration of the award and vesting the property, 9(3) capital A was introduced in the Act 1 of 1894. That was not done.
Award not declared. Award not declared.
Not declared because, my lord, the property has never been acquired even.
Very good.
So, therefore, my lord, but the construction that has been done, which is permanent in nature, they are not in a position to return it back to me. Now, my lord, if you also kindly turn to section 9(3)(a) once, what collector ought to have been done in
Act 1.
in such a situation.
9.
Section 9(3) capital A, West Bengal Amendment.
Right to fair compensation দেখছি। কল্যাণবাবু, কল্যাণবাবু, ল্যান্ড অ্যাকুইজিশন একটা বার করুন 1894 ওইখানে আছে তো। হ্যাঁ, ইদি নিয়ে গেছে কেন? ওটা নিয়ে গেল কেন? আজকে কোন মামলাটা বল?
আমার বইটা
এইখানে
দিন না যশোর।
এখানে আছে, এখানে আছে, দেখুন না, এখানে বার করুন, এখানে আরো একটা বই আছে। আজকে তো অ্যাক্ট 1 অফ 1894 কোনো মামলা হয়নি। ল্যান্ড অ্যাকুইজিশন অ্যাক্ট। কে নিয়ে গেল? এখানে দেখুন না, এখানে নেই। আপনি তো নিয়ে যাননি বইটা। না না, এখানেই ছিল, কালকেই তো দেখলাম 1894। কোথায় সব বইগুলো মাঝে মাঝে খেতে যায়? কালকে কালকে কি দিল বক্সে? বুঝে উঠতে পারি না বাবা। হাইওয়েজ অ্যাক্ট, ওটা সেন্ট্রাল অ্যাক্ট না?
Lordship, kindly consider the subsection 3 capital A of section 9. It's a West Bengal amendment.
Yes.
The collector shall also serve notice to the same effect on all such persons known or believed to be interested in any land or to be entitled to act for persons so interested, the possession whereof has already been taken on requisition under section 3 of the West Bengal Land Requisition and Acquisition Act 1948 as reenacted such and such, and in every such case the provisions of subsection 1 of section 455A, section 6, 7, 8 of this act shall be deemed to have been complied with, provided that the date of notice under this subsection shall be the date of reference for the purpose of determining the value of the land under this act. So until and unless this is being issued, neither my property is being acquired, nor any declaration, nor any award can be passed in absence of determination of the market value, because the date of issuance of notice is the date of determining the market value.
Date of reference
for market value.
Hmm.
Suppose today the 938 notice has been issued, that whatever the market rate has been prevailing on today, that will be the market value.
Date of notice under this subsection.
This subsection 938. Provided that the date of notice under this subsection shall be the date of reference for the purpose of determining the value of such land.
So no notice was issued.
No notice was issued. Now, my lord, now the act repealed.
Yes.
So therefore, my lord, for the purpose of determining the compensation, the prevailing act is, my lord, 2013 Act. So I paid an compensation for under the 2013 Act upon initiating a fresh proceeding under 2013 Act. Now, my lord, what is the case that has been made out in the report in the form of an affidavit used by the state?
Yes.
Kindly I turn to the, my lord, the report. Page 2.
Yes.
A, B, C, that is the admission that your lordship will at subparagraph C, your lordship will find, but notification under section 4 were not published. That is their admission. Next, my lord, E, which I disputing this. Disputed in respect of the language, that 80% of land value has been paid. My lord, with the greatest respect, my lord, statute does not say that 80% of the land value. 80% of the ad hoc compensation that has been provided in section 8 of the Act 2 of 1948. Act 2 of 1940. In that book, your lordship will also find the later part.
It is there here.
Yes. Section 8, my lord, kindly have a turn to section 8B. Section 8, capital B. On account payment of compensation in advance, where the state government requisition any land under subsection 1 of section 3 and decide to acquire under subsection 1A of section 4. Kindly mark that portion, not decide, not acquired, decided to acquire. It may, notwithstanding anything contained in the foregoing provision of this act, immediately after taking possession of such requisition land, make an estimate about the amount which is likely to be determined under subsection 1 of section 7 as compensation of acquisition of such land, make a summary inquiry about the person interested in such land, and after taking such security as it may think fit proper, make to such person advance on account payment towards the compensation up to 80% of such estimation. Because so therefore, my lord, it is not correct to say that land value can be determined only when property is being acquired. Kindly see, my lord, decided
it is a tentative assessment.
Tentative assessment, because no market value can be determined in absence of section 4(1)(a). So that is their only case.
Tentative assessment, which may be likely to be granted as an by way of compensation.
So
while
therefore,
passing the
suppose today I am making an estimation, and after 5 years I am publication notification. So market value will be on the after 5 years. So that is their only case, my lord. That 80%, my lord, I am saying very well. If you paid 80% of the ad hoc compensation,
that will be adjusted.
That can be adjusted. And moreover, my lord, there are nothing has been said apart from this. So, my lord, I respectful submission before your lordship will be this is a admitted position that property has been requisitioned, property has been acquired. Till that I am the owner of the property. So, my lord, for the purpose of determining the market value and payment of compensation, my property first required to be acquired, which can be done only after under the prevailing act, which is prevailing as of date. That is the right to fair compensation act.
Yes, madam.
First of all, I mentioned before his lordship that the land has
Kindly adjust the microphone, madam.
Lordship, the land has been acquired. And
acquired.
Lordship, I'm coming to the point, Lordship. Lordship, as per LA case LA 2 17 1987 88. Lordship, I am coming in the page number 2, Lordship, paragraph A of my report.
Page number
2, paragraph A. 2A of my report. Lordship. LA case LA 2 of 17 of 1987-88 had been started as per the requisition received from the requiring body, that is Executive Engineer, Kakdeep Irrigation Division. Lordship. Thereafter, that the shoot land was requisitioned after publication of notification under section 3(1) of West Bengal Act 2. Lordship. Thereafter, the possession was handed over to the Irrigation and Waterways Department. This I am this I'm placing, Lordship, paragraph number C, Lordship. Possession was handed over to the Irrigation and Waterways Department on 7th February 1990 for the land which was requisitioned, but notification under 4.1a, which was not published. Lordship, thereafter, that the Shidwell land was taken possession. 4D, paragraph number 4D, that the Shidwell land was taken possession on 7th February 1990 and the same land has been utilized for construction of DIA HP sluice. Lordship, next Lordship, that the 80% of the land value has been paid to Sudhir Singh on 24th April 1990 and the said land was recorded in the same of the father of deceased Anant Kumar Singh and Sudhir Chandra Singh with 50% share of each total acquired land, and 80% land value was entirely paid to the deceased Sudhir Chandra Singh on an application made by both Anant Kumar Singh and Sudhir Chandra Singh since deceased. Now, Lordship, I am coming to the official record, Lordship. Lordship, first is the page number 5, Lordship. This is the Form 1, Lordship. This is of 1987-88, where the construction for HP sluice of Mouja Shapkhali, jail number 5, P.A. Shagor, Executive Engineer, Kakdeep Irrigation Department.
Mr. Pan has not disputed such contents, sir.
Lordship.
Then what would be your submission with regard to the prayer?
Lordship, here the land has been taken possession, which Mr. My senior friend has stated that the land has not been taken, but that is not the correct.
No. He has stated that possession has been taken.
Lordship.
Without completing the process of acquisition.
Lordship, here, Lordship, what happened? That is the amount also has been paid. That is 80% of the amount. And that we have also annexed, Lordship, that the amount has been paid.
It is not disputed, madam. Try to understand. What is the case? He says that the acquisition process has not been completed.
Lordship.
So thereafter, 2013 Act will apply. Because that Act is no more in the force. What have you got to say?
Lordship, then the direct purchase policy...
Why there is an Act?
But no, Lordship, in that Act also, Lordship, there is one problem is, Lordship. Lordship, kindly come to page number 14, Lordship, once.
Of your report?
Of my report, Lordship.
Yes, sir. Yes, madam.
Lordship, here what happened, Lordship? This is to bring your kind notice to the collector, South 24 Parganas has to report by filing affidavit on 5th March to stand on taken. It is stated that Shidwell land was requisitioned and possession was...
Same thing stated.
Lordship, what happened, Lordship? The notification under section 4.1a was not published.
Check down. Very good.
my lord, I must be here to my client. I'm also praying for pair C and D. Pair D I am entitled to because the requisition period I was entitled to, my lord, the rental compensation under the law. And pair C is, my lord, since 1st of April 19.
He will take care. District magistrate will take care.
ছিল 20% পেয়েছে কত? Now matter is over.
Yes.
We were discussing
80%.
one judgment passed by a coordinate bench where the rest of the amount was being asked to be paid. Wrong judgment. I'm not naming anybody, but that
was not upset.
Based on our ability.
yes.
And so am
I am ready to meet all the points. Cite it.
And because of your submission, I have learned something.